Okay, good morning, everyone. Welcome. On behalf of CREATEC Bulgaria, I'd like to thank you all for joining us today on this webinar on navigating the intellectual property in China. I would like to thank our partners from the IP SME Help Desk of China for supporting this initiative and to organizing today's seminar. We greatly appreciate your support and your commitment in helping European SMEs in their journey to Chinese market, in better understanding that and to protecting their intellectual property when engaging with it. This is particularly timely and valuable for our companies that are joining a trade mission for China Joy. This is an event coming at the end of this month, so it's really helpful for them. And without further ado, I would like to welcome our hosts today, Ms. Lisa Wu, IP Business Advisor, and Lisa, the floor is yours. Thank you very much.
Thank you. Good morning, everyone. And before going to my section, I'd like to have my colleague, Jennifer Cao, to introduce our project. Jennifer, the floor is yours.
We don't hear you.
Sorry. Okay. Good morning, everyone. This is Jennifer from China IP SME Help Desk. I'm the project officer at this desk, and thank you for giving me a chance to show you a brief picture about this our organization. China IP SME Help Desk is a European-funded project. It's designed to help European small and medium-sized company about their IP. That means the intellectual property right issue in China. It's designed to provide very informative information to help them to make a decision about when they have IP issue. About how to define what means the SME in line with the European Union standard. The company less than 250 employees and its turnover less than 50 million euros is the SME, small and medium-sized company, can benefit from our project because all the services we provide is free of charge. So first, the core service is inquiry helpline. The email address is for SME to send us any IP-related question in China. Normally you will receive a reply with 3 working days. And if you want to talk with our IP business advisor, you can also book a one-on-one online consultation with this email address. The discussion can be one specific case, or I have some IP issue, or I want to understand how the IP strategy in China, or even just want to know the IP landscape in China. Whenever the question is, just feel free to book the IP one-on-one consultation with the IP business advisor. Besides the helpline, we also offer some trainings, workshops with collaborate with our partner. The training can be very tailor-made topics, like today's webinar it is, or it's very basic IP topics. For example, on 25th of August, we'll have a webinar on China's new trademark law, because China adopted amended trademark law later of June, I think, and it will come to force on 1st of January next year. That's the purpose. How we will discuss some long-term impact or about the new trademark law during this webinar. So if you're interested, just visit our website. All the scheduled activities available on the website. And besides the training, we also offer a really widely range of self-learning materials like infographic, case studies, some IP tools, some IP guidelines covering all major IP topics, and some industry-specific guides. So just visit our website, you will find something interesting. And just here is the example about the China fact sheet. And also you can see this is for creative industry guides. All are free of charge. Download from our website. China IP SME Help Desk is really a part of larger international help desk. Here you can see the 6 help desks and just in focus on different jurisdiction. But the service is similar, more or less the same, and all are free of charge. So it's easy, very easy to access the regional website where the EU, Europe, the website below here, and you will enjoy the service from us. Thank you. That's all about us. And also it's my great honor to introduce our today's speaker, our IP business advisor, Ms. Lisa Lu. Before joining the help desk, she used to work for a really famous law firm in China. And she holds double master degrees in China and the University of Hamburg. She has a really strong background experience about in the field of trademark protection or enforcement, copyright, unfair competition, etc. So, and also the experience covering the different, here you can see it covering different industries and support different larger company and the small medium-sized companies. So if you have any IP related question, just ask us. Lisa could be helped. Okay, that's all from us, from my side. Now I give the floor to Lisa.
Thank you, Jennifer, and I hope everyone can hear me well. Good morning, Bulgarian companies who plan to come to China. My name is Lisa Lu, like Jennifer already introduced. It's my pleasure to introduce IP overview in China to everyone today. And at the end of the training, I will also give some practical advice to you who is going to attend China Joy, which is an interesting trade fair focusing on the digital entertainment in China. So why IP is important in China? I'm sure you had already understand why it's important in China, because that's why we are here to listen to this training, this webinar. But I just making things more clear for you to understand. First of all, IP give you exclusive right to exploit your development, such as software, your games in China. Without IP, someone else could copy similar developments you already have without paying you anything, and you are not the exclusive owner of your IP. And for a lot of you, you may develop games and you want to launch in China. And if you want to launch in China in the app market, keep in mind that you will be asked for software copyright registration certificate. We will go through this copyright registration in detail more, but without these certificates, you will not be able to launch in Chinese app. Therefore, it's IP is directly related to your market entry in China. And if you have comprehensive IP profile, then your partner and investor will be more interested in your products, because they do not want to risk themselves into a possible IP infringement situation. And of course, IP generates additional revenues, such as royalties, such as license fees. And it can also prevent your competitor from using your ideas, your developments, your games. And lastly, with registered IP, you can take action against the infringement in China. Even sometimes without a registered IP, you can still do so, but it's still very rare for SMEs because you do not have enough reputation in China to prove you have the unregistered IP in China. Therefore, for SMEs, we always recommend if you can protect your IP before coming to China, please do so, and please do it as soon as possible. And to understand IP principle in China, you should keep in mind of those three major principles. First is registration that applies to trademark and patent. In Europe, unregistered IP is more common, like for industrial design, for copyright as well. I'm sure a lot of companies, I assume in Bulgaria company, there's no copyright registration system, but in China, copyright registration is it's an option you can choose. And even though copyright registration is not mandated, but if you want to enforce your rights, especially like in the e-commerce, in the website or the e-commerce platform or the service provider, such as TikTok, such as Bilibili in China, you will be asked for the copyright registration certificate. And for trademark and for patent, of course, this is a very basic proceeding you have to go through. Secondly, IP is territorial rights. That means if you have trademark patent already registered in Bulgaria, that doesn't mean you have the right to register in China. You have to make sure if it's international IP, you have to make sure it's designated in China. That means the protection extends to China. It's not automatically extend to China, okay? And if you want to focus on China market, then you can also consider just register one directly with the Chinese authority. Without the registration or the separate proceeding in China, unfortunately, your IP will not protect it in China. You cannot use your European IP and ask for the Chinese authority to protect it. And first to file principle means whoever is the first to file patent or trademark or copyright in China, they can claim they are the owner of the IP. They have the right to use it. Therefore, if you unfortunately already encounter bad faith registration, such as trademark, which is very common, unfortunately, you will not be able to use your trademark until you clear those bad faith registration trademark. Again, prevention it's always more cost efficient, and protect your IP in China as soon as possible. Ideally, it should be before you come to China market. The main types of IP in China are very similar with Europe. That include patents, trademarks, copyright, trade secrets. In patents, there are three types of patent: invention patent, utility model, and industrial design. Invention patent is more like patent, most of us refer to. It protects the new technical solution, and any improvements to a product or process can be protected as well. And for certain type of software, it can be patented in China as well. But those software has to solve a specific technical solution using technical development, using technical application. It cannot be all types of software. And if you want to patent in China, those solution has to be new. It has to be different from anything else in the market. And you have to protect it from publishing to the public before you decide to patent your invention patent in China. The second type of patent is utility models, but I'm sure it's not that relevant to all of you because we are talking about in a digital world. And the third one is industrial design, which is more relevant because graphical user interface can be protected in China as well. If you develop a very unique GUI, and it applies to computer, applies to phone, it applies to different device like pad, you can consider to register it as the industrial design patent in China. And you will have 15 years of protection term. And for video games company, trademark is very important because that's the name of your products and that's the logo of your products. Therefore, always consider registering trademarks as soon as possible. And in China, unfortunately, English is not a common language. You should consider a Chinese brand name for your products. That will make it easier for the customers to remember your brand, remember your products. And that will be a very important step for your marketing strategy in China as well. And I already mentioned about how important copyright is because this is directly relevant to the market entry in China. Therefore, considering register software copyright if you have any game product, and if you want to register that as copyright in China, you will be asked to file the first 30 pages of source code and the last 30 pages of source code in China. And it's very straightforward procedure. You basically file everything, all the documents you are asked for, and then you will be registered. Nobody will check whether or not your game is different from anyone else in the market. Well, this is also misused by your competitor as well, because the authority doesn't check the software copyright. Again, register it for your own products in China as soon as possible. And besides source code, you can also consider to register some of the promotional material like video, the banner, the other kind of materials as copyright in China to protect your ideas. And for the algorithm data source and certain type of source code that you do not want to share with anyone else, you can consider to take measures to protect it as trade secret. And if it's really important for your company and you do not want to share it, or it is your know-how, then seriously consider trade secret protection. That it's a very strong weapon for you to protect your IP. And later on, I will also introduce what kind of measures you can take to protect your trade secrets, including signing an NDA with your partners. And AI has been developed very greatly in China. As a matter of fact, China is one of the world leading markets in terms of AI development. And when we talk about AI, the law in China are not very clear yet, and there's no single law called China AI law. The law here relevant to AI are very comprehensive in different multiple layers. So for European company to understand AI landscape in China, it could be very tricky. However, there are just a few principles you can keep in mind to avoid making some mistakes. First, AI cannot be an author of your copyright or the inventor of your software patent, and it has to be human beings. And there is no text and data mining exception under the current copyright law in China. If you want to conduct TDM, you have to ask for licensing and or sign a contract with the data owner. That's a little bit complicated, more complicated. It could cost some more time for you if you want to use the data here. However, it's important step that will avoid you from future conflicts with the Chinese company or other companies in China. And if you have to process data and collect data, you should refer to China data protection laws. Again, there's no single law called data law. There are multiple layers of law. Therefore, I always suggest SMEs to talk with IP experts before collecting, processing data in China or from China and used in Europe. And a lot of European company may have this idea that you cannot infringe your rights in China if someone copy your product like games or copy the other physical product like machine, but that's not right because in China there are actually very comprehensive and multiple options of enforcements. And if after you identifying any IP infringement, such as counterfeiting or unauthorized sales of your software or your game online, or even worse, if there's any leaking of trade secrets of your know-how, the first step is not contacting the infringer. It's always collecting and preserving evidence. This step is essential. It's the most important step. And it could be the key that whether or not you can win your case and stop the infringement in the future. This step is specifically it's very complicated in China because Chinese courts and other authority have very specific requirement of what is the valid evidence. For instance, if you only have the online sales or online sales records on different e-commerce platform or the service provider websites in English, that's not enough because ideally all the evidence should be in Chinese. That means you have to translate those European website into Chinese. And in addition to that, some evidence has to be notarized. Specifically for those contracts or for the emails or for the correspondence you have with those infringer, if there's any. For those evidence, you have to notarize them, and before handing over to the authorities. Otherwise, those evidence will be invalid. And if you have online evidence, you can use blockchain technology, making sure there's a time stamp on those evidence, online evidence. Otherwise, the Chinese authority will assume those evidence is not authentical, and they can refuse this kind of evidence. Therefore, if you identify any infringement, things could be a bit tricky, and you should talk with the IP expert to making sure you take the first step correctly. And after the evidence collection stage, then you can consider different options. For instance, if you find a copycat game on Bilibili or on YouTube, or on the other platforms it's popular among those game users, you can consider to contact the service provider and ask them to take down the copycat products with a precondition. You should have copyright registration certificates in China. If not, you can also, it's also an option that you provide the evidence that you develop this game and you are the first one launch this game in the market. You owe the copyright of this game. It's possible, but compared with the copyright registration certificate, this approach, you will have to provide a lot of evidence and translate into Chinese. And if you have strong evidence of infringement, you can also send a notification letter to the infringer, ask them to stop infringement, or have a lawyer to send a cease and desist letter to the infringer, which is, according to my experience, CND letter, cease and desist letter works better, but you will have to pay lawyer fees to your IP expert who supports you. And if it's trademark or patent infringement, you can also consider to complain to CNIPA, and which is China National IP Administration, the authority who is in charge of IP in China. And you can comply with them and have the bad faith registration removed. It takes time, usually at least 2 or 3 years. And it will cost you money because you have to hire a local lawyer to do so for you. And if you found any counterfeit products, which probably not that applicable for you, but just in case in the future you have this situation, you can also inform the other authority, like market regulation authority or police. They can detain those counterfeiting products and conduct a raid to the warehouse, just in case. And this authorities, they react very quickly and they can also put a fine on it on the infringer. However, again, for European company, you should work with local IP experts to do so. And before you decide to go to the litigation, you can also settle your disputes by mediation or by the arbitration. Litigation is the last resort because it costs you a lot of money. You are thinking about more than 10,000 euros to go to a court for a case. Therefore, if you can choose other solutions, please do so. And if you found the IP like the counterfeits online, you can also consider internet court, which can solve your problems in a quick manner. And just if you it's easier for you to understand Chinese IP landscape if we do a comparison between Europe and China. First of all, what is the common between those two systems? Patent and trademarks can be extended internationally. That means you can file a trademark via the Madrid system. You can file a patent via a PCT international system. And the trademark lasts 10 years in both systems. Invention patents last for 20 years in both systems as well. However, the enforcement in China has to be with registered IP, but in Europe, you can enforce your IP without registration. An invention patent usually takes shorter time to get it registered in Europe. However, it takes 3 to 5 years to do so in China. And for design, I mentioned that in Europe, you don't have to register your design. You will get a 3 years protection. But in China, you have to register your design. Otherwise, you don't have any protection terms. For utility model, it's less common in Europe, but it's more common in mainland China. And keep in mind that customs in China is very useful because it can inspect both imported and exported goods. So, there's another difference which is highly relevant to you is copyright again. Copyright lasts 50 years in China, while 70 years in Europe. So if you are considering copyright protection in China, you should have a strategy that's which only lasts for 50 years, not 70 years. Keep in mind of that difference. And here are some main IP concerns. IP concerns a European company have when entering into China markets. First, it's the bad-faith registration. It's theoretically illegal. However, it's still very common. There are still many bad-faith IP registration. With the updated law, we expect to be less common, but we will have to see what will change, especially the trademark bad-faith registration. And if you do not register your IP as early as possible, then someone else might do it. That's bad-faith registration. You can still manage to overcome it, but it's costly and complicated. And a lot of SMEs still enter the China market without the proper IP registration. However, they will find themselves couldn't survive in these markets if IP is not registered properly beforehand. And if you try to use the public database, for instance, if you just want to search a trademark in China or search any Chinese company information, you will find it very complicated, especially if you are not based in China or you don't have Chinese ID. Unfortunately, we cannot find any solution for that, at least currently. Therefore, if you have any need to use any public database, you can contact me or contact any business support organization. They will find a way to support you. And again, for e-commerce platform, you will find the infringer are more sophisticated, and it will be you will find it very difficult to preserve the evidence because they disappear so quickly, the infringing links. Therefore, you should do more regular market monitor, even though it's more complicated. You can consider to have AI agent to do so for you. And you can always use the notice and take down procedure via provided by the e-commerce platform. all the e-commerce platform or service provider in China has to provide this kind of service, but always get your IP certificates ready in place. And for enforcement, it exists in China. You can, as a European company, you can use the enforcement mechanism in China, but keep in mind that it's costly and time consuming. It's just a common problem around the world. It's not just China that's enforcement is time consuming or costly. But it is China's specialty problem that evidence collection is more complicated. And the burdensome for rights owner is higher compared with other company. Even though you win over litigation or over a mediation, the damage awarded to you is relatively low, and you might find yourself unable to obtain compensation even though you win a favorable conflict dispute. And again, the counterfeiting from China is still very common. According to the statistic, more than 40% of the IPR infringing goods entering the EU in 2024 were from China. And regarding trade secrets, and trade secret infringement is still rather difficult, especially for European companies, because again, the evidence collection is complicated and difficult to navigate it. And you will find it's easy to have Chinese partner to sign NDA or NNN. However, whether or not they comply with those agreements, it's another story. Therefore, always make sure your Chinese partner to understand the NDA and NNN before they signing it, making sure that they understand your expectation. And here are some common mistakes. I hope every one of you can avoid that in the future. So first mistake, if I have used my trademark in China, my trademark is protected in China, which is wrong because again, you have to register your trademark in China. And if I have IP registered in Europe, that means my IP is protected in Europe. No, it's not true. IP in Europe doesn't mean you have protection in China. Mistake number 3, I do not need to register my IP before attending the trade fairs in China. Keep in mind that without registration, you don't have any protection in China. Mistake 4, with international trademark certificate, I can enforce my rights in China. Again, double check if the certificate is in Chinese, because international trademark certificates only in English, and the Chinese authority does not read English. You have to have it ready in Chinese beforehand. Another mistake, IP registration already costs money. I do not want to spend extra budget for the searches before registration. You have to run trademark search or patent freedom to operate before any registration, making sure they still registerable in the market. Otherwise, it will be a waste of your money to have them registered. Next mistake, I have trademark registered in China. The customs will automatically inform me of counterfeiting. You have to train the customs to make sure they are familiar with your IP. Next mistake, the screenshot photo of infringing online shop counterfeits should be enough to prove the infringement. Again, that's not enough. You have to translate them and notarize them. Otherwise, the evidence could be invalid. And if another mistake, I have IP registered in China, so I can safely use in Hong Kong, Taiwan, and Macau. That's not true because there are 4 different jurisdictions. Another mistake, my friend recommends a Chinese company to be my manufacturer in China. I can cooperate with this company. You cannot do it without any background searches. You can ask me to do the background search for you, which can help you to identify any red flag of this company. Another mistake, making my Chinese partner sign an NDA will damage our business relationship, which is wrong, and NDA is really important. And if your Chinese partner refuses to sign an NDA, that itself is already a red flag that you should not cooperate with this company. Okay, and how do we prepare for China Joy? Actually, a lot of steps I already mentioned. I just make a list for you, so you can check this checklist and making sure you prepare yourself well before coming to China, join ChinaJoy. First, you should audit your IP to making sure those IP you already have protected in China or to be protected as soon as possible. Trademark for logo brand, patent for industrial design for the innovation, copyright for the software for the game itself, logo, packing, banner, brochure, and trade secrets for those unpublished business information. For GIs, it's not relevant for you, but domain names, do you have domain names and protected already? And then register your IP in China regarding the trademark, patent, copyrights. And carefully selecting what information you are going to display. If it's relevant to your trade secrets, then tell your employees or tell the software developer that do not share any of those details with the Chinese customers or any audience during the ChinaJoy. And prepare NDA in Chinese as well to protect your trade secrets. Prepare it so you can sign it as soon as possible with your potential partners before sharing any information with them. And you should also prepare documents, including if you already have IP in China, or if you don't, then IP in Europe. That's maybe will be useful, but it's better than nothing. Have those certificate of IP ready. And if you have business license, not sure in Bulgaria if you have one, but if you do have business license or any information showing case that you own the business, keep that and translate into Chinese. And if you want to hire a lawyer or you already have a lawyer in China, sign the power of attorney so the lawyer can be ready. And in case there's any infringement, you identify during the ChinaJoy. And you should also learn about the trade fair by knowing where is the IP complaint center is. And if you already have the exhibitor contract, be careful about any terms related to IP, or the different trade fair has different terms. And unfortunately, I cannot find a template of this kind of contract of ChinaJoy online. If you are interested, you can also contact me and I can read through the contract and highlight which terms you should pay attention to. And of course, if you already have any potential meetings with exhibitors in China, you can do a background search to them before actually meeting them. And here are some common mistakes when signing NDA with Chinese partner. First of all, language. Second of all, which law should be the governing law? It should be Chinese law because IP is territorial rights. You should consider Chinese law instead of European law. Otherwise, it might be difficult to enforce your rights in China. And we will share these slides later with you also. You can also go through this checklist. And one thing it's very important and doable for you before the ChinaJoy is the background search or due diligence on business partners. So how to study a business partner? You can use an official database, which is National Enterprise Credit Information Publicity System. However, it might be impossible for you to use it if you are in Europe or you don't have Chinese ID. Again, you can send a name to me and I can run a background search for you free of charge. And from this database, you can learn who is the legal representative. This is important because it should be this person to sign NDA or any contract with you. And you can also learn what type of business they are doing, whether or not they are in normal operation. It could be a bankrupt company who is still running business. For those companies, you have to avoid them. But you don't know this information until you do a background search. Whether or not they have any litigation or disputes in history, the very obvious IP red flag is whether or not they are involved into IP infringement in the past. If so, then you want to avoid this company. And unfortunately, annual revenue, it's not one of the information you can find from the public database. And how to handle the meeting with business partners. This is some practice advice. Before the discussion, you should sign an NDA. Therefore, you need to prepare in advance and you need to do the background searches to understand your potential business partner better And when share the information, you can invite them to build your business property at a later stage, or just share a very, very general idea during the China Joy. And if you decide to enter into a new phase of international negotiation, you should always sign a MOU outlining the structure of the deal and what information to share, and again, confidentiality obligation for both parties. And in the final agreement, which is the most important one, you should always identify who owes what information, and what if your Chinese partner develop your software, your games products, who owes which part. This kind of terms should be negotiated in different part of stage. And you should be able to continue to monitor your partner. You can even pay unannounced visit to China to check your partners, whether or not they still follow what you expect them to follow. Okay, lastly is the takeaway message. IP is your asset. Obtain IP protection before attending trade fairs to avoid loss of rights. And make sure you protect trademark patent, register them, and of course copyright before the trade fair. And research your competitor who will attend the trade fairs, and as well as potential partners. And if you identify any infringement, remember to ask for IP expert to collect and preserve the evidence. You can always contact us, China IP SME Help Desk. There are different ways to find us, but the most direct way for me to address your problem is to book a one-on-one consultation with me. You can either use this QR code or go to our website to book a meeting with me. It's free of charge. You can book multiple meetings with me. There's no limit. And also, I'd like to know all of your feedbacks about today's event. It's very important for us. We are European Union funded project, so all your feedback is very valuable. We will be much appreciated if you can leave your feedback to us. And again, you can find us in X, in LinkedIn, YouTube, or if you have WeChat, which I'm sure most of you will use it after your China Joy journey, you can also scan this. You can also follow our WeChat accounts. There are many ways to find us. And thank you, everyone. If you have any questions, now is the time. And if you already asked a question, I will start to answering it. Thank you very much. Okay, I did not see any question unless I missed it.
Yeah. Thank you, Lisa. Maybe may I ask you a few words or a little bit of tips about the webinar on 25th of August about the new trademark law, why it's important, or the SME attended is really important, why it makes sense. Just a little few words.
Yes, thank you, Jennifer. So yes, we are going to have a webinar regarding the latest amendments of trademark law in China on 25th of August. Why is important? Because it will change your strategy, especially branding strategy in China. For instance, how to prove you use your trademark in China. And we also hope to see less bad-faith registration trademark in China, which is good news for SMEs. And on the other hand, we also should try to make sure SMEs or European companies coming to China with comprehensive strategy on preserving the use of evidence in China, as well as how to defend your trademark rights in China. There are many knowledge in that webinar. One thing I forgot to mention is the new trademark law will come into force on the 1st January 2027. So for European companies, you have around half years to prepare for that. And now is the best time to learn about the new trademark law and how you can protect your trademark right, or how you can establish your trademark right in China. And this is essential for game company because branding is very important for a video game, online game company. it's a very essential steps for you to come into China market. So register this event.
Thank you very much. Yeah. Let's see whether we got any questions. Yeah, people can type your questions in Q&A box, and we'll read it out, and Lisa will give you advice about it.
I see a question. It's about the cost of patent application in China. Thank you for this question. We actually have a IP tool, IP cost tool you can use to search how much to file an IP in China. Maybe Jennifer, you can send the IP cost tool link here. But just answer your question quickly. How much to file a patent in China? Generally speaking, you are because you need as a European company, you need a patent attorney to assist you. Therefore, most of the cost it actually goes to the patent attorney. You are looking at around 2,000 euros to 5,000 euros to register an invention patent in China. If it's an industrial design patent, it could be around 500 to 1,000 euros. That depends on how complicated your patent is and whether or not your patent will be refused by the Chinese authority. That again, the cost could be increased. And if you decide to go through international patent registration by Hague system or by PCT, it could be more. And you could wait for a longer time to get it done in China. Hope that answers your question. Okay, I also find another question. What's the best way for companies to translate their name and logo in Chinese? Yes, there are two ways, generally speaking. One is the pronunciation. Some company will translate their Latin words according to the pronunciation to Chinese character. That doesn't necessarily reflect the meaning of the Latin words, but that's easier for the Chinese consumer to remember, to pronounce. That's actually a smart way. And of course, you can always translate your English, your Latin mark to Chinese according to the meaning. Like the big IT company Apple, they just translate it into apple, that fruit in Chinese. That will work. But most of the company, as far as I know, will still use the pronunciation. Those are two ways to translate the name into Chinese. But although translating name into Chinese, it's more like a strategy, marketing strategy, it's still trademark relevant. That means you should making sure nobody else in the market use similar Chinese name. Otherwise, you cannot register those Chinese name in China. Again, that will cause you a problem. So I would suggest you to consult with IP experts and making sure those Chinese translating name can be registered as trademark as well. Okay, is there any more question? And if not, well, you can always book a meeting with me and we can discuss more according to your strategy, according to your logo, and according to what's your plan in China.
Thank you very much. It was very helpful for me, I believe for the companies as well. I encourage all of them to reach out to you by email or book a one-on-one. I believe this is the best way that you can meet their needs, their questions, etc. So thank you very much.
Thank you.
Thank you for your time.
Thank you, everyone.
And have a nice day.